Hi everyone, it's Shaya Lewis-Dermody here. Thank you for joining us. I've just started the broadcast a couple of minutes early because I can see there's lots of you waiting to get in. So thank you for that, and thanks for joining us on the Friday. And I can see that some of you have started filling out the polls and stuff. If you scroll down, you can see the polls, which helps me to better understand my audience, where you're from and who you are. Chat box is open too on, I'm not sure what side it is for you. For me, it's this side. Let me know your name, where you're from, and that really helps other service providers and other people as well to connect and know who else is here on the audience. I really find that helpful. It was particularly good for the last webinar that we run on the coronavirus. There was heaps of service providers on that particular webinar, and that was really helpful. So I can see we've got some legal advisors here, which is always good. Some lawyers. I saw some lawyers on the email list, so thank you guys so much. Hi, Emma from South Australia, from Anglicare, financial counsellor. No speaker or camera, but I'm here. Thanks, Emma. It's debatable as to whether you're missing out or not to not see us. Emma, just know that the slides that you can't see, because I think the slides always add a bit of value to the presentation. So keep in mind, Emma, that will get sent to you in terms of a replay. So you'll have that there. Hi, Teresa Clark. Hi, Teresa from Relationships Australia. I know, Teresa, you're a family dispute resolution practitioner, so awesome to have you. Lawyer from WA, thank you for this webinar. You're welcome, and thank you for joining us. That's really cool. Hi, Karen. Karen O'Keefe, Uniting Communities, also a family practitioner. Final year law student, Hannah Rice. Hi, Hannah, how are you? We've got someone from Northern Territory. We've got Trish from Women's Information Service in Adelaide. FDRP, Rasa. All right, we've got heaps of you. So it's just after. Cool. All right, so it's just after time to get started, so I will. And I'm just looking down at the polls. Interesting. Someone's not from SAWA, Eastern States, but is from other. I'm guessing that's the Northern Territory. Alrighty. Anyway, I'll get going. I just wanted to let you guys know I've got Elham Rabba, who's our firm manager. She's been on and off with the Family Law Project for 7 or so years now, on and off, but she'll be here on this webinar helping me out. So she'll be following the chat box, and there she is. Hi, everyone. She'll be following the chat box, and she'll be also looking at the questions. You can see there's a question section as well, so pop your questions there. If I get distracted when I'm presenting this webinar, hopefully Elham's on board in the chat box, and she'll be able to help you and direct you accordingly. I want to thank everyone for joining. I'm not sure if it's just me, but it feels like at the moment there's so many webinars, which is great, and a great use of time whilst we're still in semi-lockdown. I guess lots of us are still working from home, so it's a great opportunity. However, my email inbox does feel a little bit flooded with webinar. So I want to particularly thank you for joining today, because I know that there's lots of webinars on offer at the moment. My general caveat that we give at the start of these webinars is it's not specific legal advice. And also the law differs in each state. So I can see we've got someone from NT, WA, we've got Eastern States, NSA, we've got pretty much the whole of Australia. I'm not, in terms of states, I'm not sure if there's anyone from Tasmania, but it looks like everywhere else is covered. The lawyers that are here will know that the law does differ in each state, particularly with respect to estate law, which is quite a very interesting jurisdiction. It's it's a difficult jurisdiction. Family law is more broad and it's more national, aside from WA, which is a little bit different. And I'm coming from WA today, actually. I was looking outside just before a sort of semi-storm just started, so if the rain does pick up and it is on cue, I apologise for that noise. Alrighty, so I'll just move the slide there, a bit about me, and I'll move that on very quickly. For those that don't know me, there's a link to our website as well. And Elham, perhaps if you put our website in the chat box if anyone wants to look at that while we're going along. Got away with words. What I mean by that is this webinar is really directed towards people who have separated. And I know, particularly from the chat box, that we've got lots of practitioners and service providers listening. So when I say your ex or your client and so on, I'm obviously referring to your clients, okay? So the reason I'm using the terminology your ex-partner and so on is because we do also have clients that have joined us, and also these webinars get popped onto our YouTube channel at a later date where we have lots of, the general public watching these replays. So for them, it's just easier for them to understand when I use that terminology. So Elham as well, if you can pop our link to the YouTube channel at some stage, that'll be good. The other thing is I'll use the words the Act, the Family Law Act and so on. I'm talking about, lawyers will know, 1975 Family Law Act, and in WA, I know we've got some WA people here as well. We're talking about the Family Court Act of 1997. They both kind of mirror each other. My aim in this webinar is to really, remove the legalese and ensure that you're able to follow this as best as possible. So I'm not going to delve into specific sections of the legislation or bore you and so on, and that because that is pretty much guaranteed to bore you and remove you from this webinar. So I'm not going to do that. You have my guarantee. I will however, have some references on the slides so people who are legal advisors who have tuned in can see those references to the particular section of the Act, can see the reference to case law, and they'll probably be able to tick their CPD box as well, which we as lawyers all love. So what are we going to cover today? I'm going to cover how you can protect your assets whilst you're still alive. That's the first thing, after you separate, and then how you can protect your assets as well in terms of your estate when you die. So there's two, sections to this presentation: how you can protect your assets now and or upon separation, and then how you can protect your assets from your ex-partner when you die. I'll give you specific examples from a family law perspective. I'll talk about time limits. We'll discuss how you can formalize your property matter to protect yourself. We'll talk about protecting your superannuation. We'll talk about whether it's in your interest to do nothing at all. Not many lawyers say that, but it might be. We'll ensure that you're protecting your loved ones. We'll talk about reducing the chance of your ex being in charge of your estate when you die and being a beneficiary or an executor, which I'll talk about. And then at the end, we'll very quickly touch on how protecting your estate when you die from your ex is not just about the will. Okay, we'll have Q&A at the end, and then there'll be some offers at the end as well. So I just want to pop your questions in the question box as we go along if I haven't covered anything. I can see we've got a really good turnout. A lot of people watch their replays of these webinars because they can't make the live, but we've actually got a really good live turnout. So thanks again, guys. Okay. So if we sort of take it back a bit, I think when we're looking at how to protect your assets from your ex-partner, what is a partner? What is a relationship? So I'll just quickly summarize that, and it might seem really obvious, but it's perhaps not. Okay, so a relationship is where the court, the family law courts, has jurisdiction, and the matters where the court has jurisdiction to deal with a property settlement is where a couple is married, which is obvious, or where there's a de facto couple. And I've put the section of the Act there where the legislation defines what a de facto couple is. But I think, generally speaking, it's really good to know that de facto couple is generally a 2-year or longer cohabitation. Cohabitation is a little bit interesting, but I'm going to say that for the general purpose of this webinar. and or have children together. So you might only be a de facto couple for, say, 1 year, but have a child together, young child. Or if there's been any substantial financial contributions, those matters are quite rare. So we're looking at types of relationships as when you're married or when you're de facto. Okay, and I just wanted to get that clear at the outset because that's where the court's got jurisdiction to deal with your matter. So we looked at who can the court deal with in terms of property matters, who in terms of a couple can affect a property settlement, but what exactly are assets of the relationship? So when you're looking at from the Family Law Act perspective, we're looking at all assets. So we're looking at assets that are in sole names and in joint names. And when you think about it, it's not uncommon, for example, for real estate to be in either sole or joint names. Superannuation is always in your sole name. We're looking at assets such as cars, shares, bank accounts, investments, household contents, business interests, trusts. I think that's about all I had on my list, but basically it's all up for consideration, and it's irrelevant as to whether the property is in sole name or joint names. Okay, that's the main point there. We just had a couple new people join us, so thank you everyone for joining us. North Lawyers in New South Wales. Hi, Jenna. So in terms of what the options are to formalise your property settlement or to deal with your property settlement, you and your ex-partner might decide not to do anything, and that's fine. There's a lot of risks perhaps with that, but there's nothing forcing your hand to affect your property settlement. It's sometimes in your interest not to pursue a formal agreement, and that will be one of the things I talk about shortly. But in terms of how you can formalise your property settlement, and most of the FDR practitioners that have joined us will know this. So you're talking about consent minutes of order. That's when the agreement that you've reached is drafted formally in the proper format, proper consent minutes with the application that goes along with that, and that's registered with the court without actually having to go to court. It's filed and you get the court seal or stamp on it that then gives it the effect of a binding court order. So that's one option. The second option is what's called a binding financial agreement, or a BFA, as I've put there on the slide. There's really strict requirements around drafting a BFA. The legislation is really, it's quite complex, and the court can set aside BFAs if they're not drafted properly, if there's not been the proper legal advice. Both parties need independent solicitors to give that advice and so on. It can be a really good option to protect your assets if you've reached an agreement with your ex-partner that's perhaps favourable to you. So, for example, I had a matter last year, late last year. I was acting for the wife. Husband, for whatever reason, basically decided that he was going to forfeit his entitlements that he would have under the Family Law Act, and instead essentially said, look, my client, the wife, could have majority of the estate. He was seeking a really nominal payment to essentially cover his legal fees, but other than that, he agreed to this. Now, this agreement that was reached between the parties was never one that the court would agree on, would never sign off on or make court orders about, because it didn't meet the criteria of the Family Law Act. It was not a fair agreement. But what BFAs enable you to do is reach an agreement on basically anything you like, as long as it's been drafted properly, there's been that real good independent legal advice and so on. So for my client, the wife, in those circumstances, I said, look, we got to strike while the iron's hot and get this drafted, get it signed, ensure that it's done really well in terms of, letters of advice and ensuring that the husband got that advice as well. It was a fantastic outcome. So my tip there in terms of protecting your assets is, look, if you are able to reach an agreement that's really favourable to you, that perhaps is an agreement that there's no way the court would make that order, consider the binding financial agreement. That's really the only circumstances where I recommend a BFA. Because it's open to scrutiny and to be contested, we generally recommend consent minutes of order. So options to formalise is consent minutes of order, your binding financial agreement, or court orders. All right. So why finalise? And I've put the reference there to section 81 of the Act. And what that section says is exactly, look, it's to ensure that the orders finally determine the financial relationship and to avoid further proceedings. Because the last thing you want after this separation, and now the financial separation with your ex-partner, to go through that process, which is not pleasant. No one wants to come and see us as lawyers, okay? But when you get to that point and you've got those final orders, you want that assurance, you want it to be final. So that's the whole purpose of court orders or consent minutes of order. And the tip there I've just popped on the slide, court orders or consent minutes of order provide you with the certainty that any future property that you acquire will be protected. If you're going into a new relationship, if you get a new job that's much better paying, your superannuation increases, the value of property increases, etc., you want those final orders to protect you, to know that your ex-partner can't come back for what do they call it? The second cherry, is that the expression? Anyone know the expression? Please let me know. I'm known for getting my expressions mixed up, and I tend to combine expressions as well. Second slice of the pie, second bite of the cherry. Thank you, Teresa. I'm glad you were listening too. Okay. All right. Many of you practitioners, such as you, Teresa, know that there's different ways to reach an agreement with your ex-partner, and many of you practitioners listening, that's exactly what you do in terms of property matters. You assist clients to negotiate and ascertain what the value of the asset pool is and reach as much of an amicable agreement as possible. The problem is that some people don't take that next step to formalise, and the practitioners listening know that probably what happens with most of you in your practice is that you'll have parties attend. If they reach an agreement, it might be drawn up informally, might even be a print off from a whiteboard sometimes, depending on how time poor that you are. But you'll always tell the clients, look, this is not legally binding. The problem that I see is that people don't take that next step to formalise that agreement reached. It's very common. And I've already talked about the problem with that, in that it's really leaving everything open. So the tip is to get everything formalised so that if there's a second bite of the cherry, your ex-partner's not coming back and saying, well, look, we might have had an informal mediation or an informal written agreement, but it wasn't signed and it wasn't formalised. So my ex-partner, the value of property's gone up, super's gone up and so on, and I no longer agree to what we agreed however many months or years ago. So that's a really, really good way to protect yourself. Avoid trying to do it yourself. I've seen clients go off and try and download things on the internet. I've seen clients have things drafted up and then getting it witnessed by a justice of the peace. Both parties might even, with good intentions, get it witnessed by the justice of the peace, but it's not legally binding. So unless you've had it drafted properly, sealed by the court, it's not going to be legally binding. And of course, you're not getting the legal advice as well. Okay, how are we going for time? All right, just looking at the questions as we go. Alrighty. Time limits. This is a really very important thing for everyone to be aware of. When you separate, the amount of the length of time that you've been separated is critical, and you must know this in terms of ensuring that you're protecting your assets. So the time limits are in terms of how long you've got or how long your ex-partner has to initiate proceedings with the court or to ask the court to resolve your property division. So time limit's critical. You have 12 months from the date after a divorce. If you do not have an agreement by that time and your consent minutes of order are not registered by that time, then you need to seek leave or permission from the court. 12 months from the date of divorce. You have 2 years post-separation for de facto couples for the same thing, to request the court to deal with your property division. Again, if you don't do that, then you or your ex-partner needs leave or permission from the court. And usually what leave or permission means is it's very difficult. You need to establish that there's grounds of hardship. And I've put there for the lawyers playing along, I've put there a couple of cases for you to have a look at. I won't bore everyone else with those cases, but if you're interested in researching more around hardship and how difficult it can be for that leave to be granted from the court, then please take a look at that. So my tip is to know your time limits, and I can tell you I've had clients who've been absolutely burnt by this. So I had a client, I acted, this was for the wife again. We do act for husbands as well, equally, okay? But in this particular matter, I acted for the wife. This was maybe 5 years ago or so. She and her husband had separated and divorced, and it was over 10 years later that she found out that the property that she was living in, which was essentially the husband's investment property, he had given her an undertaking that you can live there the rest of your life. It was relatively amicable. And she was not wealthy by any means, but she was being provided for in terms of living in this other property, which was in the husband's sole name. He then decided he was going to sell that property, and she was out. And she brought an application, and it was, like I said, it was over 10 years out of time. We had counsel, we had senior counsel, barrister involved, and we couldn't get her over the hurdle to establish that she would suffer financial hardship if she was not given leave or permission to file out of time. What we've done, I think we've had about 3 in the past 6 months at my office. We've had what's called preservation applications. So we've had clients where we're helping them with negotiations, but we've not yet reached a resolution, or they've come to us and an agreement's been reached or nearly reached, but not quite. It's probably another month or 2 off. And we're mindful of the time limits approaching, that 12 months post-divorce or 2 years post-de facto separation. And what we've had to do for these clients is lodge what's called a preservation application, which is essentially get that application in to ensure that the client's property matter is going to be protected. So we usually keep it short, and we'd like to avoid it, because if you can avoid that in the first place, the client's avoiding, or you're avoiding, those legal fees. But sometimes you've got to, because if you don't get it in, then you might lose your interest. So the tip is to know your time limits. That also goes to, well, if property is in your sole name, and or if the main asset is superannuation, which is always in your sole name, you need to know your time limit, because why would you do anything to affect your property division at all? If the time limit runs up and the asset's in your sole name, then it's going to stay with you. So why would you do anything except get your divorce in order as soon as possible and update your estate documents? So sometimes the advice that we give clients is, look, be mindful of these time limits. Assets are largely in your sole name and protected. Let's roll it out. Let's run through that time limit, hope that we get to the end of it and there's nothing from your ex-partner, in which case your assets are fairly well protected, and or it's going to cost your ex-partner a lot of money to dispute that. So sometimes our advice is know your time limits, get your divorce order in place as soon as possible. And divorce is really very easy to do, and usually we refer clients off to do their own divorces because it's it's quite straightforward. All right, so time limits, that's why it's important. Know if the asset's in sole or joint names. Because if the asset's in your sole name, like I just said, it might be in your interest to not do anything. Sometimes so let's look at real estate. So real estate's going to be held in three ways. Someone's sole name, nearly put the wrong finger up then, sorry, joint tenancy or tenants in common. If you have with your ex-partner tenants in common, which is relatively rare, but it does happen, if you're tenants in common, you can deal with your share of the title, your share of the house, as you see fit, providing there's no court proceedings. If you're joint tenants, what that means is that if you die, automatically, if there's no court proceedings, automatically your share of the title will transfer to the survivor. So you really got to be mindful of that. And unfortunately, in those matters where property is held jointly, real estate is held jointly, you're probably going to have to do something about it, because if you sit on that and just go, oh, look, our relationship's pretty amicable, we'll let this go along a couple of years, we're getting along fairly well, we'll deal with it later. But if then the relationship or the communication breaks down, you might have difficulties having it dealt with by the family law courts because of that time limit. And if you have to go into a different jurisdiction, which is looking at real property, it's going to cost more, and it's not worth it. So get that legal advice. The other thing around getting your property settlement formalised, which is not a tip that I put on there, is stamp duty. So if you get your property settlement formalised by a BFA or consent minutes of order, you'll ensure that you are not having to pay stamped duty on the transfer of that property as well. Okay, just change slides. This tip around superannuation, it's going to apply to everyone that's listening today, okay? So not just for people who've separated or are thinking of separating, but absolutely everybody. There's ways to protect your superannuation from your ex-partner immediately, and also to protect superannuation from your ex-partner when you die. So from an estate perspective, what I would encourage everybody to do, regardless of your relationship status, is check with your superannuation trustee who you have nominated as your beneficiary. This is one of the first pieces of advice that we give to clients that come in to see us for a first appointment. Who is your nominated beneficiary? This is one of those perhaps like admin type things that we can tend to put off. But if you've separated, there's a good chance that your ex-partner is still named as a nominated beneficiary with your superannuation trustee. And it's a really relatively easy thing to fix, and you don't need lawyers to help you with that. You contact your trustee directly. But you really need to get on top of that. And that's a really good way to protect that asset, and a very common oversight. And I can tell you, I have literally seen someone who has been, divorced, and was probably 15 or even more years later, had not changed that. So you need to get on top of that and check with your trustee. And I'd say that for everybody, because it's not something that we are sort of regularly thinking about. If you don't change that as a separated person, your trustee is bound by different law, not the Family Law Act, and the super trustee will determine how it's distributed, and it won't probably form part of your estate. It will be dealt with separately. And you want to really avoid your ex-partner getting their hands on that. If you've got children, you'll want to ensure that they're the nominated beneficiaries. So I can't stress how important that is as a first piece of advice for legal advisors who are listening, talking to their clients, and also for clients listening, if you've recently separated or if you're unsure, just get on the blower and get that done ASAP. Okay. Still on the topic of family law and how you can protect your assets post-separation, I want to talk about windfalls, which is a windfall is like a lottery win, lucky you. And I want to talk about family inheritances because it does happen. I've seen it happen when I worked in country South Australia, in a town called Port Pirie. Anyone from that way, give us a shout out. I grew up in the mid-north, South Australia. I had a client who she and her husband won, I reckon I was a new lawyer back then, a baby lawyer. I reckon it was about $2 million that they had won post-separation, and it had to be considered in the property division. So it does happen, okay? Karina from Whyalla. Hi from Whyalla. Where are you from, Karina? We always joked in Port Pirie that there was only one town worse than Port Pirie, and that was you guys in Whyalla. Although I think you've stepped up these days. Property does not fall into protection merely because it's an inheritance or a windfall. So if you receive a family inheritance post-separation, or if you go and have your lottery win post-separation, then it's not protected. And I can't stress that enough. And I'll just briefly talk about that. Okay. Because I've seen examples of this, and there's a lot of case law on this as well. And can you imagine if you've separated and then you go win the lottery, and sure, your ex might not get half of it, but if they're taking a chunk of that, then I don't know about you, but I wouldn't be too happy about that, okay? So even, and when I'll try and keep the legalese to a minimum, but even if the court is looking at dividing property in what we call a two-pool approach, so you're essentially putting that windfall or that inheritance in a separate column and dealing with it separately, it's still going to form part of the ultimate division of property, okay? So for the lawyers there or legal advisors, I've put 3 cases there. They're super interesting. Missile and, well, for me they are, but I'm a bit of a legal nerd. So we've got Missile and Missile 2010. That was a 23-year relationship. After separation, the husband received $9.5 million, not insignificant. So it was after separation, the court took this two-pool approach. So basically said, look, we've got to consider this 9.5 mil a little bit separately, but ultimately there was an adjustment which saw the wife getting some sort of benefit from that huge windfall. The matter of Erfrison, and I'm not sure if I've pronounced that right, but in that matter, and this is a common matter that most lawyers will know about, but in that matter, the wife won the lottery of 6 mil after separation, 20-year marriage, and she won this 6 months after separation. So the court found that there was a separation, there'd been separate financial lives and so on, and they took that two-pool approach. So it's definitely favourable for the wife in that, yes, she brought that in, that $6 million in. However, there was an adjustment of that of $500,000 to the husband. So again, not insignificant. 500,000 of 6 mil is certainly not half or close to, but it's certainly a lot of money. And I suspect that wife was pretty peeved. I also suspect there was shitloads of money spent on legal fees because that went to the full court. The last example I'll give, and that's the Singerson and Jones, that was a 2014 matter as well. And in that matter, the husband received 3 mil family inheritance post-separation. So the other 2 matters I spoke of were lottery wins. This one was family inheritance. So again, even though it was not fully considered as part of the asset pool in terms of an equal division and so on, it still was considered in the reasons and in the adjustments, and the wife benefited from that. So these things do happen. the tips I've got there is to ensure that you're getting your divorce as soon as possible, your divorce order. If you've got that agreement reached, formalise it, because if you've got final orders in place and then you're later having these windfalls, these lottery wins and so on, it's going to make it super hard for your ex to then come back and take a grab. And I'm just looking for that expression again that Teresa told me earlier. Second bite of the cherry. Thanks, Teresa. I'm across the law, but these expressions are, I forget. All right. The other thing that I would like you to keep in mind is if you're expecting a family inheritance in the future, keep that in mind. If your relationship's a bit rocky, keep that in mind. If your relationship is good, still keep that in mind. So I'm helping someone at the moment. They are anticipating about $4 million to be inherited, family inheritance, happy marriage, but wants to ensure that if the relationship breaks down, that they are protected. So we're doing what's called a binding financial agreement to effectively quarantine that in the event they separate. We're going to protect that $4 or so million, which is significant. Relationship's good now, but I guess from our perspective as practitioners who are watching, legal or family dispute resolution practitioners, we've seen it all. So I'll just move to the next slide. I just want to summarise quickly the family law context, the tips that I've given there. Know your time limits. Do you apply for divorce as soon as possible? I've put the question mark there because it's dependent on everyone's matters a bit different, but will it give you that protection? Update your superannuation, check who your nominated beneficiary is, and that applies to everybody listening, not just people who have separated. Consider a binding financial agreement if the agreement reached is very favourable for you only. Good way to protect your assets. Formalise any agreement that you have reached by consent minutes of order to ensure that the asset pool is protected and to ensure that any subsequent asset is not considered as part of that relationship pool, such as family inheritances and windfalls. And it's also protecting property that increases in value. So you've got, for example, real estate and superannuation, both typically will be increasing in value. So you want to protect that as well and ensure that you're dealing with assets as at the time of the agreement and not in 3-5 years time when things have skyrocketed. And let's hope our super's increased by that time because it's taken a bit of a hit recently. The other tip is avoid the DIY property settlement failure because that's not going to give you the protection that you need. And if you know that you're going to get some sort of family inheritance in the future, even if your relationship's good, consider the binding financial agreement that you can do during the relationship as well, not just when you separate. If you separate, that was the lawyer in me coming out. Okay. I'm just looking at the comments here and I'd just looking at the questions. If you've got, I see there's a few questions coming through. I'll take a look at them at the end, guys, because it might be that I answer them shortly just through the presentation. But I appreciate the comments. There's lots of comments coming. Oh, Karina, my first law job was in Port Pirie. Paul Boylan was my mentor. Well, I've had many glasses of red wine with Paul Boylan. He was my very first boss as well. 3 years working for Paul. Great guy. Andrew, I think you've answered most of them so far. Thanks. Thanks, Andrew. I've not finished yet, so stay on the line. So thanks, everyone, for hanging in there. I hope I've not bored you. I hope I've kept the legalese to a minimum. The focus so far has been on family law tips and family law advice, but I want to sort of delve in a little bit to wills and estate because, believe it or not, this is also another thing that you need to be on top of to ensure that you're protecting your assets from your ex-partner. So we want to be protecting your assets in the event that you die. Okay, it's a morbid topic, but it's one that we need to have. And we want to be protecting your assets in the event that you lose capacity. So what I mean by losing capacity is you are in ICU, you might have a car crash, you might lose mental capacity for whatever reason. And stuff happens in our life that we don't anticipate. I did a Facebook Live a while ago. Perhaps Elham, put the link to our Facebook page on the chat box as well, Elham, just so we've got heaps of live videos that we do there for anyone that wants to follow. But the one I did about 3 months ago was I'd got non-cancerous, but a brain tumor in my brain. I didn't know at the time that it was non-cancerous, but of course that sort of whacks everything out of line, and it makes you reassess everything and ensure that you've got things in place, because if I do lose capacity, or if I do go under and have it removed and there's issues, I need to ensure that I've got things in place. If I go to ICU, for example, if I lose capacity, anyone can have a car crash, anything can happen, and we've all seen that through COVID. So there's two things here. There's protecting your assets if you die, when you die, it's going to happen. There's protecting your assets in the event that you lose capacity. Thanks, Elham, for posting that link. Okay, so you want to ensure that your loved ones are in place as opposed to your ex-partner. I really want everyone to read this slide, and for those that I know there was at least one person listening who doesn't have the slides. Even if you have property orders or a binding financial agreement, that does not rule out an application by your ex-partner on your estate when you die. Even if you have property orders or a BFA, that does not rule out an application by your ex-partner on your estate when you die. I've said that twice because it's so important, and a family law settlement in itself may not terminate your dead moral obligation. Okay, so now that I've got your attention, I hopefully do. One of the most effective and cost-effective ways that you can ensure that you've got this protection is to update your will. And this is, I'm going to talk very briefly about wills, and I hope everyone listening in terms of service providers and so on really take notice of this as well, because a lot of this in terms of getting your wills and estate documents up to date is relevant for everybody. Obviously, I'm going to take a family law focus and delve into that, but it's going to be relevant for everybody. So your will set out the directions of your assets when you die in terms of who your beneficiaries are going to be. And what a beneficiary is the person who benefits from your will. So the people that you leave your stuff to, leave your assets to. The other really important thing to know is what your will does is it nominates who your executor is. Now, your executor is the person who takes care of your estate. They will do things like apply for a grant of probate. They will access your real estate, your bank accounts, transfer property, and make sure your beneficiaries are taken care of. That, in a nutshell, is what your will does. Now, believe it or not, there are famous people who have died intestate. What intestate means is without a will. I find this remarkable. Bob Marley died in 1981. He'd been diagnosed with cancer 4 years before he died. His estate at that time was 30 mil. There was dozens of claimants because he didn't have a will, and there was fighting amongst his widow and his 13 children. He didn't have a will. Teresa, apologies, go to another webinar. See, I told you, Teresa, there's lots of webinars. Yeah, catch up later, Teresa, thank you. Jimi Hendrix died in 1970. It was a 30-year estate battle, and he had children out of wedlock, which didn't help. Martin Luther King Jr., he died intestate despite having many death threats. Ultimately, he was assassinated in 1968. His estate has been an issue for 40 years, contested. Kurt Cobain, he died at 27. self-inflicted gunshot wound in 1994, and he left a suicide note, but he did not leave a will. Karen O'Keefe, off to another webinar. Well, I think I'm competing against Justice Charlotte Kelly, who is running a webinar at last minute, and she's going to override me. I think we've had 2 people drop off now because she's running a webinar through relationships, not relationships, pathways. So no problem. I understand Her Honour will take precedence for 2 of you who've left. That's fine. All right. So they're the people that have died intestate. But wills and estate matters are not just for the rich and famous. It's not just for millionaires. Anyone who has children, super, we've all got super, or property, any sort, should have an estate plan. I want to just go back to what I said at the start of the webinar here, in that this area of law is very complex and differs from state to state. Jurisdictions differ, so I'm going to talk a little bit generally. Why would you update your will from a non-legal perspective? Well, when you die, your family is left with trauma and grief and stress, and it brings out the worst in people. And if you've got your will in order that really makes it clear to people around what your wishes and directions are, and that you've chosen the right person to be your executor, it can remove some of that stress and grief that they might have. You want to ensure that your ex-partner is excluded, full stop. You don't want them as a beneficiary, I presume, and you certainly don't want your ex-partner appointed as an executor. An executor, I've explained the role, but can you imagine if your ex-partner has been appointed under the law? Because you've died intestate, the law will set out what happens. It's a nightmare. And if you throw in blended families there as well, which we see a lot more of, it is even more complex. And this is where the lawyers make their big bucks. Alrighty. So separation from your spouse does not revoke a will. If you're married and you're separated, your will is not revoked. You need to reread that. If you're married and you've not updated your will since separation, you need to. Separation from a de facto does not revoke a will. Okay? A subsequent marriage will revoke your will. If you commence a new de facto relationship, that's not going to revoke a will. So you need to update your will at that time as well. An estranged spouse will be treated as a happily married spouse in most states. What does that mean? It means your former domestic partner might receive all or some of your estate. They might be appointed as your executor, even if you have children from another relationship. So you need to avoid that happening. And if you die intestate, then you're going to, sorry for the knock there, you're going to have to do letters of administration as opposed to a grant of probate, which is more costly. And the law will essentially determine the order in which your beneficiaries are dealt with. And I've put a case there for the lawyers following of Mackenzie and Lucas. It was a New South Wales decision. The parties in that matter had been separated for 18 years. The deceased had a new de facto partner for pretty much 18 years, that whole time. But there was only an informal property settlement only. So like I was talking about earlier, they hadn't done consent minutes of order. The estate was about $4 million and there was no will. So orders were made for that ex-spouse, didn't get it all, but got $200,000. And I'm pretty sure that was not the intent of the deceased, okay? So it just shows that these things really need to be sorted. And if you don't have your estate in order, then it's more likely to be challenged. It's more likely your ex-partner will challenge your estate if you die intestate. And I've set out the legislation there. The important thing for people to know is that it does, all those acts, all those legislations include ex-spouse in terms of the ex-spouse being entitled, an entitled person to be able to bring an application. It's a costly process. Letters are exchanged, lawyers are involved, you'll probably have mediation and then court proceedings, and tens of thousands of dollars will likely be spent. Estates are more likely to be contested when you die intestate without a will. more likely to be contested as well when you're looking at blended families, where there's children, where there's stepchildren. If you've entered into a new relationship but have children from a previous relationship, it's even more important at that time to ensure that your children are being protected. Often we see people come to us in new relationships doing blended families, joint wills, leaving everything to each other, and then to respective children, all the children, stepchildren, blood children. Problem is, if one person dies, when one person predeceases, everything's going to go to the survivor. What stops the survivor from changing their will and for their stepchildren no longer being provided for? There's different ways to do that in terms of mutual contracts and so on, but it can be expensive and complex. But these are the things that you need to keep your mind to and keep your documents up to date. That's a really good way to protect your assets. So other reasons to ensure you've updated your will: avoid greater legal fees. You want a trustee for your children. So when you draft your will, if your children are not yet 18, everything that you give to them will be held in trust until they reach 18 or a bit older if you choose. But the executor of your will has the obligation to ensure that those funds are being used for medical, education, those sort of things. So you want to ensure that that person that you nominate is the right person. You get advice on super, specific gifts. You might want to leave specific gifts, and obviously decide your beneficiaries and funeral directions as well. You can also appoint guardianship for your children. So in the event that you die, who do you want to look after your children? Is it your ex-partner? It might be. You might not like that person anymore, but they might be a good parent and have a loving relationship with your children. Or it might not be. That you might not think of anything worse. So what we can do in your wills is ensure that you're stipulating your preferred guardian of your children in the event that you die, and exclude the people that you want excluded. So the tips there, I'm getting towards the end, but the tips are: separation in itself is not enough to give you that protection. Your estate's less likely to be challenged if you've got a will and final property orders, which is what I've just said there, okay? Separation in itself is not good enough to ensure that your ex does not have an interest. You still want the people in the right place, which I've said it before, and you don't want the government to determine. I'm skipping through my slides quickly because in true lawyer style, I've been speaking more than what I said I would. So we're getting there. I just want to touch on free wills and will kits. They're a recipe for disaster. Public trustee is separate, so they will do free wills. However, they will take a commission of your estate, a percentage of your estate, and you don't get to have the people you entrust in place to do the things that you want to do. Will kits can lead to further mistakes because they can be challenged. I've put there the South Australian legislation, the Wills Act, but each state has similar legislation that essentially sets out how wills have to be drafted and signed and witnessed. So there's so many intricacies, and we see lots of people getting these $20 will kits, and ultimately they're challenged, okay? So ultimately it's going to end up costing your estate more money because they've not been signed or drafted properly. The strict requirements include things like, two people signing at the same time, using the same pen, no other marks on the page, one single staple, no other clips, no codicil, which is an attachment. There's all sorts of mistakes that can be made. Often we get people that download wills from the wrong jurisdiction. So a common one is New South Wales. They seem to have more online wills available through different online services, but it's the wrong jurisdiction because the client doesn't live there. So that's another mistake that we see, and we see people end up spending more money trying to fix up the mistakes. We also see people giving away assets incorrectly. So they're not taking into consideration that they might no longer have those assets when they die, or the value of those assets might change at the time of their death. So it's all well and good to go, oh, I'll leave I don't even know what a Ferrari costs, let's say $100,000 Ferrari to little Johnny, and you die 20 years later. Well, that Ferrari is either useless, worthless, or no longer in existence. So where's little Johnny provided for, perhaps? These are the things that you've got to consider. You can give away houses that are no longer owned as well. This people they think differently when they're drafting their own will, so it can end up being costly and more open for challenge as well. And that's what you want to avoid. You want to avoid your ex-partner challenging your estate. That's your end goal here. Other documents, and this is going back to the capacity issue. So you want to have your power of attorney document in place, so that if you no longer have capacity, so if you're in a car accident or on life support, for example, you nominate who you want to look after your legal and financial affairs when you die. You don't want your ex-partner doing that. So that's another document that should be updated as soon as possible after you separate. There's a few different ways to do that, but we don't have time to go into that in this particular webinar. But I'll just say that if you don't have that in place, and if it's contested with your family, there's going to have to be applications made to a tribunal, and there's no guarantee that your ex-partner will not be appointed, okay? Advanced care directives or power of guardianship, they're called different things in different states, but essentially it sets out your medical preferences and your death preferences when you die as well. Medical and dental things. It includes end-of-life preferences, whether you want to be resuscitated and that sort of thing. Again, it's something that you want to ensure, I presume, that you don't want your ex-partner having any sort of involvement in. So again, the best way to do that is to, when you update your estate package, which is your will, your power of attorney, and your advanced care directive, have all that updated at the same time as soon as possible. So I'm going to, most of you have stayed on. We had about 5 people popped off only to get to the other webinar, which, as I said, was by Her Honour Justice Kelly. So I can understand that. I'm just looking through because I've just finished with my slides, guys. I'm just going to look through the questions now. Kayleen, what happens when lawyers refuse to act and you can't get anything to court? I'm not sure exactly what you mean by that, Kayleen, but what I would say is that if you're talking family law court, there'll always be a lawyer, I'm sure, prepared to act for you if you've got merit. And you can always self-rep as well if there's an issue, although if there's no merit, you run a cost application against you. I'm not sure if I understand your question, Kayleen. Perhaps on this slide I've just put up, my email address is there. Just send me an email with a bit more detail. Money that I earn after separation, will that be included in the asset pool? That's a really good question. So it's not going to be considered, and every matter is different. It's actually, property matters are really complex. It might not be included per se in terms of it's up for grabs or up for division, but when you file proceedings in the court, if you have to, most matters we try and settle out of court, but if you have to file in court, you're going to file a document which has your updated current financial situation, and you have an obligation to disclose that to the court. So what your bank account statements are and so on currently, what your current income is, for example. And it might be that those monies can't be included in the pool particularly, but it is relevant in terms of what your earning capacity is, and earning capacity is one of the issues that we look at when we're dividing property. And I'm going to run a webinar purely on property matters and the 4-step process that the court takes in considering property matters. But that's a really good question. Chris, I'm in the process of the divorce stage, but it's asking about children custody and settlements. Is there a way around this? No. So, Chris, if you're talking a divorce application, keep in mind a divorce application is separate from a property application. So I think you're purely talking divorce application. You don't necessarily need to have orders about children or property, but you need to tell the court that as part of your divorce application. Emma, a lotto win after 12 months of divorce doesn't mean it needs to be split though, right? Question mark. Emma, no, that's not right. So if you go back to the section where I spoke about lottery wins post-separation, if the property matter has not been finalised by way of court orders or consent minutes of order, and there's no formal divorce, then a lottery win is still up for grabs. Not going to be 50-50 perhaps, but it's still going to form part of the asset pool. I'm just reading through these questions, guys. There's heaps there. Thank you for contributing. Julie's got a question about 3 years ago, we did our own property division. I've since bought a house for my son and me. If I sell it, does my husband get a share of it? Even if I divorce now, can he still claim it? He pays no maintenance or child support. Julie, if you've not formally divorced and you've not formally done a property division, then there's scope and availability for your ex-husband or your husband, because you're not divorced yet, to bring an application. So you need to get some legal advice. If you feel free to flick me an email. Karina off to court, a couple of people off to the other mediation. And I'm just looking through the questions. Chris, last question. Do these rules apply in all states, SA, Victoria, etc.? Chris, it's, as I said at the outset of the webinar, Family Law Act is a national jurisdiction with some little exceptions with WA, particularly around de facto couples in WA. With the estate and family inheritance provisions, each state is quite different. So I've spoken generally. However, the concerns that I've raised generally are applicable in each state, but each state has some little differences that you need to be aware of. Okay. No worries, Chris. Andrew, so you've gone through the process of separating, settled and distributed the assets, and had judgment by the registrar, including a BFA, and finalised the divorce. Is there scope for the ex-wife to claim? So, Andrew, I'm a little bit confused there because a binding financial agreement is not dealt with by the court. So a registrar of the court wouldn't have done that. A registrar of the court signs off on what's called consent minutes of order. So I'm going to presume that you're talking consent minutes of order. All right, Andrew. Yeah, that's... Send me a message, Andrew, because that's complex. It's a little bit complex. BFA, but I'll speak generally. BFAs can be challenged, like I mentioned earlier in the webinar. They can be challenged, and you need to get legal advice about that. It's a really complex area of law. Megan, can the ex divorce you without you knowing about it? Divorce applications are required to be served on your ex-spouse, and your ex needs to make all best attempts to serve you and file what's called an acknowledgement of affidavit of service, confirming that they've served the other person with the divorce application. There's some exceptions, and sometimes you can't always find everybody. So in those circumstances, you need to show the court that you've made your best attempt to serve them, and that may include a whole series of things such as searching the electoral roll, having a process server attempting service and getting that person to do an affidavit and so on. It's rare for an ex parte order, divorce order, to be made, which means a divorce order without your knowledge. Alrighty. Okay, I'm going to leave it there, guys, because I'm mindful of the time, but what I've put there on that last slide, a peace of mind package, if you want to take advantage of that, just send us an email and we'll give you a scope around the work that's involved for that as well. 770, all inclusive, includes your legal advice, which is so important when you're talking property matters as well, your advanced care directive, and your power of attorney document. So the whole peace of mind package, 770. If you are a new client and you want to chat about your property matter, you can book instantly on our website. Or if you would like a copy of our family law book, just send us or send me an email and I'll take care of that for you. I'm going to wrap up. We've gone past the hour. Thank you so much for all the questions. It's been really good and very engaging. I'm pleased to have so many of you on here as well. And thank you for those watching the replay. So I'm going to stop the broadcast now. Thanks again, guys, and hit us up for our next webinar as well, and we'll talk to you soon. Okay. Bye for now.